exhibits, and if you could point me in the direction of that, I would appreciate it. It's something that we were discussing internally, and I may have glossed over it, but I'd like to at least have a copy if we could.
I'm not sure I ever saw it either, unless it was just submitted as part of
You have
these.
a copy. Mr. Velde has a copy, and we can ask that copies be made and it be entered into the record.
Thank you.
So would we make that then you? Is that right?
You.
You. Okay, so you will be. Brief memorandum or something, email.
It's like
from
an email.
Email.
Mr.
He's embedded his.
Okay, Doug's gonna make copies for us. Okay, with that then, can we go ahead and proceed?
Yes, thank you.
Okay, so, Ms. Schneider, I'll let you kick back off with questioning you had of Ms. Hyman.
Thank you. I'm going to be asking, starting out by asking Ms. Hyman a few questions about Exhibit C, or Z rather, as in Zorro, which is the chronology she's prepared.
Okay.
So the first page, Ms. Hyman, as you testified, begins with the actual submittal of the Plat application on August 1 of 2017. If we turn the page, your actual chronology begins on January 17th of 2017. So can you use this document and explain to us what happened before the August 1 submittal?
Sure. So on January 17th, 2017, we met with Keith Niven, and that was the meeting that we've talked about, where we informed him that we wanted to submit an application, or that we would be submitting an application to divide the property into lots. At that point in time, we were thinking that we would do a binding site plan, or a binding site plan and plat. There was some back and forth with Mr. Niven, where he first believed that binding site plans weren't allowed in Issaquah Highlands under the development agreement. We pointed out that they were. He talked about the fact that they had never really done one before and didn't want one. At the pre-op meeting, so then we requested a pre-op meeting, and the city said no. So in February, we requested the pre-op meeting. The city said, no, you can't have a pre-op meeting. You need to do an early collaborative meeting first before you can schedule your pre-op. So at the collaborative meeting, we, at that point, were talking about both a binding site plan and a plat. And so we had that collaborative meeting between the city and Shelter on March 21st, 2017. At that meeting, we had very specific conversation about vesting and how vesting of a plat works. That was what I noted with respect to the letter that we entered into the record as an exhibit, the March 27th, 2017 letter from Mr. Niven to Mr. Abdulnor, right in that same time frame, like within a week, and Mr. Niven described to us at that collaborative meeting the same thing that he had described in that letter, which was that your plat application will vest you to the development agreement regardless of when it terminates. You also then have 5 years to file your final plat and record it, and you'd be vested for that period. And then if you submitted an SDP within 5 years of the plat recording, you would also be vested for those SDPs. And so that discussion happened early at the collaborative meeting. It was actually offered as enticement to us to follow the plat process rather than the binding site plan process, which we had initially suggested. After the collaborative meeting, we started asking for a pre-app, and our first response that we got from Ms. Sloman was that you can't even schedule your pre-app until you give me a utility plan and a traffic study, which really caught me off guard. And I think I wrote back to her saying, are you really saying that I have to do a utility plan and a full traffic study before I could schedule a pre-app? That can't possibly be right. And she said it was, but that I would need to talk to the engineering people to figure out what exactly that meant. So there were follow-up discussions that our consultants had with Dan Irvin and with, it might have been just with Dan Irvin on both utility plan and traffic, and we didn't actually need to submit anything before moving forward. So once those sort of arbitrary preconditions that she had tried to impose were satisfied, then we said, which happened at the end of March, so March 31st, 2017, then we said, okay, now can we have a pre-app date? Then a few more days go by, and then Christopher Wright, I think, was the one that informed us that, no, you can't have a pre-app date until you submit a full preliminary land use application package. So we immediately jumped on trying to get that done. That's a really extensive process in the city. It's more akin to a full application in other jurisdictions. So it's a significant amount of work. I think, if I'm remembering the numbers right, it's like a $20,000-ish package of consultant work that's required to get a pre-app in Issaquah. But we did that, and we submitted it 10 days later, and then we asked for the soonest pre-app that we could possibly have, which the city informed us would be the end of May 2017. So we had that meeting May 31st, 2017. After that meeting, the city provided us with the pre-app meeting notes on June 7th, and we went to work on our full application. So you can see that it was, 7 months-ish of pre-process that was imposed on us before we could actually submit an application for a plat, which is pretty unusual.
In your opinion, is that 7 months of process that the city imposed on you consistent with the development agreement?
No, it's not. The pre-app meeting is listed as an optional meeting at the applicant's option. They can schedule a pre-app meeting in under the development agreement. A collaborative meeting is not in the development agreement at all. It's a creation of the city in other contexts, and they chose to impose it arbitrarily on us in this process.
You said that in discussing the collaborative meeting with the city on March 21st that that the ability to vest with a plat application was offered to you as an enticement. Can you explain that, please?
Yes, I mean, we were specifically talking with the city about vesting, and Keith offered up that he knew we were interested in vesting, and so he wanted to explain to us exactly how it worked, and he went into what I previously described, that you vest through your preliminary plat application, that carries your vesting till your final plat application or your final plat recording, and then after that period, you still have at least 5 years of additional vesting to submit your SDP, and then that vests for the SDP time period, which is 3 years.
So, did what Mr. Niven said about vesting with a plat application, did that affect Shelter's decision whether to apply for a plat or a binding site plan?
Yes, because at that point, when we went in, we were anticipating that we would be submitting both a binding site plan and a plat. Based on what he told us, and that then we saw confirmed in a letter the next week, we relied on that in moving forward with our development strategies on this property.
I'd like to turn to the development agreement itself.
Can I can I share one more thing
Sure.
from the collaborative meeting? Or may have been the pre-app meeting, but in one of those two early meetings, we asked about timing, and Ms. Sloman told us that this was a very simple plat, that she didn't anticipate that it would even get any comments, that there would be a review round of comments before issuing a decision. She thought that it would just go straight to proposed conditions that we would be reviewing, rather than comments and revision, and that she anticipated and hoped, subject to staffing, that it would be done by October of 2017. It has never really been explained to us what changed to make the plat so much more complicated and take so many more years.
So turning to the development agreement itself, and I think for this purpose, we can use the red line version that is included with the staff report under tab P. And I specifically want to call your attention to a couple of the appendices that Ms. Sloman's staff report says we're not vested to, referring to page 12 of her staff report. And under the column not used and not vested, she includes M and N and L. So why don't we go through those in order? What is the Appendix L that, according to the staff report, we're not vested to?
Well, Appendix L is processing of land use and construction permits.
And what does it, in a nutshell, say about how long it takes to process a plat application?
It shows that a preliminary plat gets a recommendation from what it refers to originally as the Grand Ridge Commission, which later was changed the name to UVDC, or the Urban Village Development Commission. It has a process that, from submitting your preliminary plat, I think it's about 90 days, give or take, to council action on the plat.
And how about Appendix M? What does it talk about?
Appendix M is titled Elections and Modifications of Grand Ridge Development Standards. I think the part that is relevant here is Section 1 on applicant elections, and 1.1 specifically talks about authorized elections. And it says that the partnership referred to in here would be the master developer, which that's sort of the shoes that we step into as property owner. So the owner shall have the right to elect to include as part of any application for, or to modify any pending or approved preliminary plat to the following pre-approved matters. I'm omitting some of the references to other types of applications that are listed, but I'm reading from section 1.1 of Appendix M. And then when you go to 1.1.2, one of those authorized elections that the applicant is authorized, specifically authorized to make, is changes in the square footage or layout of retail commercial uses, so long as the modification falls within the range of square footage acreage approved for the non-residential development areas. And then it refers to some other exhibits. If you follow that, well, I guess, so why I think that's relevant is that that's exactly what we did with our December 15th, 2017 submittal. So at the time we made that supplemental submittal, we were modifying our pending preliminary plat application to change the square footage. So one of the things that I don't know if anybody clearly pointed out was that the table of allowable development allocation changed slightly between our August 1st and our December 15th submittals. And the staff report suggests that you should only approve the August 1st submittal, but it doesn't really ever offer any reason for that. This section specifically allows us to change that layout or density, which is what we did there. So I think this section is very applicable to this plat. Further, there is section 1.2, review procedures, and it says the designated official shall not have the discretion to deny an authorized election. So we exercised a right under Appendix M. They don't have the right to deny it. They didn't actually deny it when it came in. They, in fact, used it as their notice for the application. It was not until these proceedings that we were informed that it was being, well, I don't know what we were informed. In the staff report, it says it was being deemed not vested. But now with the revised recommendation, it's very unclear what the status is. There are many references in the staff report to some application materials being vested and others not being vested. I think that puts you as reviewer in an impossible situation because I'm not sure how you review one application under two conflicting codes, which is what the city's asking you to do. So that's what I think the relevance of Appendix M is.
So what changed between the August application and the December 5th submittal? You said that the density as allocated among the lots by the table changed. What else changed?
Some lot lines changed.
And to what extent and why?
I would say that they are pretty minor changes, but they were driven by the site development permit planning that we were working on at the time. Some of the feedback that we were getting in the context of the site development permit application submittal was that the city couldn't tell if the two sets of applications were consistent. And so we came back with showing exactly how they're consistent. We felt like this was being responsive to comments that we were getting from the city on the SDP applications.
And by this, you mean you believe the December 15 submittal was your response to the city's comments?
Yes, that it was in part initiated because we were getting the feedback that where the city kept rejecting our applications as incomplete because they couldn't determine if it was consistent with the plat that they were not reviewing.
And by rejecting your applications, you're referring to the SDP and ASDP applications?
Yes, we got multiple notices from the city that they were incomplete, and ultimately it came down to just a single issue, and it was the fact that the city hadn't processed our preliminary plat was keeping them from determining that the applications were complete.
Okay, and this period of time when the city was telling you that it couldn't approve the SDP, ASDP applications because it hadn't approved the plat, was the city in fact doing anything to process the plat according to your Exhibit C?
No, we have no evidence that they had done anything at that time, because that was occurring in October and November and December and January and February of 2017 into 2018. And we did not have any indication that any review had happened on the city's part on our plat application. In fact, kind of the opposite, because when Mike Swenson was referring to how the need for the revised traffic scope came out of the SDP applications, what happened was we submitted an SDP application which was being deemed incomplete, and one of the reasons given was that they didn't know what build out of Discovery Drive was going to look like. So this was on the medical office building. And so when I gave that comment, when we got those comments and I went through it with Mike, he was like, well, wait a second, we already submitted that with the plat. Why would they be asking for that? So he emailed Doug directly and said, Doug, we got this comment on the medical office building, and it says that you don't have Discovery Drive proposal, but we submitted that to you back in August. And Doug said he hadn't seen it. Then he pulled it and he said, well, it's only 2 pages. You need to do something more than that. And so that's what initiated the meeting that occurred in January of 2018, where Doug changed the scope of what was being required for the transportation analysis.
The staff report also says that shelter is not vested to Appendix N. What is Appendix N to the development agreement?
Appendix N is the dimensions and standards table. So this one, I don't even know what their explanation is for it, because I'm not sure how you would review a plat without reviewing the minimum lot size and other density and lot dimension requirements. And that's exactly what's set forth in Appendix N.
There's a reference in the staff report to a private agreement between Shelter and Polygon. Do you have a response to that language?
I have no idea what that is. And we informed Ms. Sloman before this hearing, before she finalized the staff report, that we did not know what she was referring to, and asked her to please provide us some additional information. She did not, do you know which page that reference is on?
21.
She did not. Instead, she rephrased her reference. So it's on page 21 in the note that's under the table. She rephrased it so it says, this is apparently a private arrangement between the adjacent property owners. However, street trees and landscape plantings are required per the development agreement and will be addressed with future permits for construction. I don't know why she wrote that when I told her I don't know what that agreement is and I don't know what the arrangement is. It's obviously not the biggest issue here, but it's just not accurate.
Mr. Examiner, if I could interrupt the questions for a moment and go to the conditions. You were presented with revised conditions this morning. Many of the conditions that have not been revised are written as if the March 2019 submittal had not happened. Many of the comments in there are addressed in that submittal. So what I would like to do, rather than go through them in detail today, is ask Ms. Heim a couple of overarching questions about them, but ask for leave to submit our own set of proposed conditions once we receive comments from the city about the March 2019 submittal, which they're going to explain to us, as I understand it, why it has too much detail in it. And once we know if we can reach agreement on the plat set, then I think that's when it would be appropriate to determine what conditions.
I was gonna suggest something comparable, so that makes sense to me.
Okay. Then I won't go through the existing conditions with some of them in detail, but I would just ask her if she has any sort of overarching comments about them, and we'll get to the detail next time.
So is Ms. Heimer viewing Exhibit V at the moment that was provided today and just providing sort of a general comment? Is that what's happening?
We can talk about, well, I think her notes are on the earlier edition.
Oh, okay. I guess.
There's
I don't-
only the one
I don't think
deletion.
they're very significant, other
Right.
than 3 is eliminated and then some language up here is crossed out. Okay.
Yeah, and I think I already touched on the language that's struck out, just makes it more confusing since her staff report doesn't acknowledge the March set as part of the vested application. But hopefully that gets clarified in the, whatever they come back with. I think as several people have mentioned, a lot of the conditions are not necessary because they've already been addressed in the revisions. There's a few instances where it appears that the city is trying to reserve or create rights to impose future conditions later, which obviously isn't acceptable. Whatever rights the city has to impose conditions on other separate permits, that right exists independently of this plat approval. So I think we would ask that you make sure that the conditions are clear, that they are not, in fact, granting additional authority to impose conditions that they're not currently putting in front of you for review. There are conditions that are inconsistent with the acknowledgement that we are vested to the Issaquah Highlands Development Agreement. Number 5 is an example of that. I don't know, it might be more constructive to just
Sure.
comment on them once we have the revision in front of us. I would say on number 12, you have heard testimony today from our consultants that the reference in that condition should be to Neighborhood Collector 2, not to Neighborhood Collector 1. When you go back into the staff report where she references condition 12, she says she just assumes that it's Neighborhood Collector 1, because again, at the point that she's writing the staff report, she's refusing to acknowledge the March 2019 submittal. So she just assumed Neighborhood Collector 1. You actually can choose between 1 and 2, and you heard Mr. Valdez run through the reasoning as to why this Neighborhood Collector 2 was chosen, as it allows the continuation of the bike path that is on the other segments of Discovery Drive. So I think that needs to be corrected.
Mr. Swenson testified that he analyzed traffic from the full build-out allowed by the development agreement is there, based on your understanding of the development agreement, is there any other analysis that needs to be done to determine the impacts of this particular plat?
No.
And how does the development agreement address mitigation?
Sorry, just to be clear, that question was a little broad, but did you mean it to be broad, or were you just referencing impacts related to traffic, or you meant all impacts?
I did mean all impacts.
Okay, I just want to make sure I understood the question. So
Yeah.
your question was, other than the traffic analysis that was asked for to address potential impacts from full build-out on this plat, do you believe any other further analysis was required under the development agreement? Was that the question? I hate to put words in your mouth.
Yes, and the point I'm making is that the traffic analysis from full build-out has nothing to do with this plat. That is the analysis permitted by the development agreement. It was analyzed in the EIS in the record. The development agreement includes mitigation for all the impacts of full build-out. So we complied with the request and analyzed traffic impacts based on full build-out, even though the plat has nothing to do with how full that build-out will ultimately be. It just creates separate parcels of land. And to the extent that the proposed conditions are attempting to reserve the city to the right to oppose additional mitigation, I think the record needs to be clear whether or not there is any authority or any need for such additional mitigation in the conditions of this plat.
Sure, and not just traffic related. You're saying any type
Yes.
of, stormwater system, I don't know, development charges. I don't know if we have those in Issaquah. I haven't thought about that, but all those types of things is what you're asking. Is that accurate?
Yes.
Okay, thank you. Sorry, Ms. Hine, please, you can now respond.
And the development agreement addresses mitigation and specifically vesting to mitigation by defining development standards with capital D, capital S to include mitigation. And so when an application for an implementing approval is vested to development standards, it's vested to mitigation. So one of the things in the staff's analysis of vested rights is they don't ever mention the development agreement, that it addresses vested rights and it addresses what you vest to. And the fact that our plat allocates the allowable development across all the parcels and analyze the full build out of all of that allowable development is an indication that it should be vested to all of the mitigation, because that's one of the development standards that it vested to per the development agreement, which is the code that it vested to. And that should be reflected in the plat approval.
There's a reference in the staff report to a short plat being in the history of your property. Is that accurate?
I don't believe it is. So on page 3, in the background of history, the 4th bullet, and Ms. Sloman also referred to it in her presentation today. She refers to a short plat from 2016 that subdivided the West Ridge North into parcels for future development, including the property that's subject to this proposed plat, Lot B. That, as far as I know, that is not accurate. We were not involved in a short plat with Polygon in 2016. We are separate entities and separate ownership, and they did a short plat that impacted their property, but we were not included in that.
So was Lot B pre-existing?
Yes.
Okay.
So Lot B came out of I believe it came out of the lot line adjustment that's referenced above, the LLA 14-00002.
I'd like to go back for a moment to your Exhibit Z and the chronology that is attached to it, and ask you to turn to the second to the last page and explain to us what these dates and these statements reflect about what has happened between the community conference and today.
So it has been surprising to us, although maybe we shouldn't have been surprised, how long the process has taken to get through community conference and to this hearing today. Throughout the process, we have been asking and pushing the city to give us dates to move this forward. So we had the community conference. We felt it took the city quite a long time to draft the response memo. We committed to having our responses done within 1 business day of whenever they finished, and we did that. Because the way that was set up, we each had a response to certain topics that had been identified. Then there was a comment period, and that expired, and then a few days later, they provided us with the comments that had come in and asked us to determine whether they were consistent with code and to identify whether we were going to revise our drawings.
Those dates are incorrect, is that right? Should those be 2019 at that point?
Oh, yep, you're right. Those two
Just
should be 2019.
assumed, but wanted to be
Thank you.
clear.
Yes, so
Okay.
those two, they provided us the comments and then asked us to determine if any of the comments were consistent with code and if we were going to make any revisions. We right away responded that no, none of them were consistent with code such that any revisions were required, and we asked for a hearing as soon as possible. So that was back on October 31st of 2019. Then in November 4th, they informed us that they were continuing to work with the hearing examiner to identify a hearing date. Then again on November 14th, they claimed that they were still working with you to identify a hearing date. And then on December 16th, they informed us that they had now asked the clerk, the hearing examiner's clerk, for possible hearing dates, which made us wonder what the work with you earlier on consisted of. And then we didn't hear from them for another about a month and a half. And on January 31st, they informed us that today, March 9th, 2020, would be the first date and that they were seeking additional dates. And then on February 6th, 2020, they confirmed that it would be March 9th and March 20th.
So is it fair to say that as far as the city has informed you, the delay from October 31st until March 9th was because of the hearing examiner's unavailability?
That's what we were led to believe, that it was a scheduling issue that was causing the delay from late October until now.
Ms. Heim, I don't think I have any more questions right now. Are there any more points that you would like to make as the person in charge of this application? I think that concludes our presentation for today.
I wanted to give Mr. Lau an opportunity, but thank you. Mr. Lau?
No cross-examination.
Okay. Great. I didn't have specific, well, the dates on the working with the hearing examiner, that threw me. This was all news to me, so I guess I'm curious. I kind of want to look into that myself because I don't recall being asked about these things, at least that I'm aware of, back in November or possibly even December. The first I can remember is in, I think, January, but I don't know how. If it's appropriate for my office to produce something, it would be David Ortman is my person that schedules these things. And
Let me just say on
Sure.
that, because we were, I think, appropriately skeptical, we submitted a public records request for communications with your office, and we've only received a partial response, even though the request was submitted quite a number of weeks ago. So we're hoping for a more complete response. And if we get that before the 20th, we will obviously include that.
Okay, I might have David Ortman produce something just for the record that people can lodge objections to, but I just would like to at least put it in there, whatever we find in our internal system. Again, our system's different than the city's system. We're not city employees. We're independent consultants. We're also, attorneys. So sometimes a conversation, for instance, between David Ortman and myself would not be produced in a PRA request. But I'd like to find out when we think we were first asked about this and try to put that into the record just so it's there. And again, if people have objections, fine, but I'd like to do that as part
Thank you.
of this. So. Okay, so no questions here. So I guess at this point, we'll figure out what the plan is, and we can get through that, I think, fairly quickly. So there was discussion earlier about, actually, you know what? What do you guys think the best plan is? Mr. Lell, you're pretty good at summarizing these things if you've already thought it through.
Well, I'm struggling a little bit. I'm sorry, I'm going to ruin your name again.
Mark Valdi.
Mr. Feldy's comments earlier about his office's current scheduling and staffing constraints given the ongoing coronavirus issue and the fact that, unless I misunderstood him, that it would potentially take approximately a week to turn around a plan set. Is that correct?
It's a function of what we choose to do.
Sure.
So I think my opinion of the process is decide what, if anything, that we're going to do to the plan set. As soon as we can do that, I can take that back into my staffing situation and try to bang it out before people start trying to work remotely. That's the way to do it. That's the only way I can respond to that.
Thank you for that clarification. That's obviously pardon me, a logistical concern that we're going to have to try to schedule around, along with the city's availability and efforts as well as the applicants. 2 days. End of
Well,
Wednesday.
I think the question that I had for you, Mr. Hearing Examiner, is, are you not seeing any of this until it walks in the door on Friday, or do you need these materials ahead of time?
Ideally, I would get them ahead of time, but I can be flexible if I can at least get them. So is it the 20th is a Friday? Is that right? If I can at least get them by close of business the night before, the day before, I will make sure to give a quick review. In a perfect world, y'all work it out and the proposed conditions are agreed upon and we have a pretty simple hearing. Knock on wood, I'm not gonna fully expect that, but, we'll see what happens. But yeah, one day, not even a day, the night before, as long as I have a couple hours, I'll make sure I set aside that Thursday night to review whatever comes in.
The city will do its best to try to communicate to the applicant the specific details that the city feels should be removed from the plat by close of business this Wednesday. Does that work?
Let's say end of day Wednesday.
End of day Wednesday, that means presumably up to about 11:59 p.m., which is usually when Ms. Sloman is working.
Sure. So the idea is by Thursday when Shelter and their crew is starting work, they'll be able to see what the city has suggested and start in on that. And then, so let's see, that would put us,
That would be the 11th.
it'd be closed the day of the 11th,
right.
so on the 12th that gives Shelter a week approximately to produce whatever it needs to.
And we need some time to see what comes out, because
Sure.
we don't, they cannot pre-commit that they will agree with
Sure.
what we've sent, and we need an
I-
opportunity to review it before.
And I'm a little wary of giving specific dates. I mean, I feel like we have such a narrow window between now and when we're back here that I guess the best I can do is implore everyone to work collaboratively and accomplish as much as you can between now and then, in terms of, I understand. I mean, I agree, if you can get them whatever in the next couple days, that's great. And then I understand the engineering, a lot of people aren't gonna have access to CAD on their home computers, and if they're not able to go into the office, that could create problems. So we're gonna have to kind of play it by ear, but I think even conceptually, communication is possible that would allow, I think there's discussion that can happen about potential conditions, proposed conditions, even if the plan set itself isn't fully realized before we come back here. Go ahead, Mr. Law.
If I could make a suggestion, just listening to Ms. Heim's testimony today, and certainly the thrust of the applicant's legal argument in relation to the cities, I think it's very unlikely that we are going to realistically agree to a set of conditions, because particularly as they relate to issues like vesting, like the effect on future permit applications that we feel are part and parcel of this proceeding and are important for purposes of the city's vesting analysis. My suggestion would be that perhaps maybe after the hearing closes on the 20th, the parties would have a certain time frame to submit proposed conditions to the examiner, and then you can pick and choose amongst them on your own, rather than having us argue about that in court or try to add an additional layer of complexity in our.
Sure, I
what
mean,
should
I
be a
guess I
collaborative-
was gonna hope you guys might work it out before we meet again on the 20th, and we wouldn't have to go there, and then I was gonna suggest that we do that, but I think I get what you're saying. So I would propose, I guess, that again, work out what can be worked out, in terms of what the plan set that is under review is gonna be. That needs, I think, there's gonna need to be agreement to some extent, or else we're here prematurely, right? Because I do need to, even if my decision gets appealed, we're gonna need to know what's being appealed, and so I think at least in terms of the plan set, it needs to be clear. And because I don't really have the authority to condition or change the plan set. I mean, I can propose my own conditions, I can revise the conditions, I have that authority, and those would be appealed, but it's not like I have CAD and I'm sitting here going, oh, I think I'll change how, this looks. So I think there are two sort of separate issues there. So if you can sort anything out in relation to conditions before the 20th, great. If not, we'll cross that bridge, fully understanding that, as I think Mr. Schneider suggested early on today, there might be a point at which the applicant suggests its own conditions that are different than what has been proposed by the city, and I'll have to, use my own judgment to decide what I think is best based on what's before me. So I think that makes sense. Again, I would implore everyone to try to work it out, but this process has been going on a long time, and as professional as everyone is, sometimes you just can't come to agreement. So does that make sense to everyone?
Yes, thank you.
Okay, and then Mr. Lell, I was curious, but Mr. Schneider did produce that what are we calling it? I called it a pleading. I think that's an appropriate, your standing objection. I don't know if it requires any kind of a response from you, but you did just receive it today. If you think you need to make a response, I wanted to at least give you that opportunity.
Thank you. We'll
You can
consider
submit
that.
it on the 20th, that seemed fair, Mr. Snyder? Came in today, and none of us had an opportunity till today to review it.
And some of the objection may have been mooted out by the response
Sure.
we received today. So
Yeah, okay. So I think that all makes sense. So this is the sort of, I think tentatively the city has said, it will get the applicant sort of, this is what we believe is too much information, or however this is what we want to see on what will become the final plan set by the end of the day, Wednesday, by the end of the day, not the end of the workday. And then you guys will sort out to the best of everyone's ability, getting the plans. If we don't have them by the 20th, at least hopefully we can talk conceptually about, what they will end up looking like, and, we'll get them into the record at some point shortly thereafter. But anything that needs my review, I think please try to get my office by, it would be let's say 5 p.m. on the 19th. And that's gonna be the only guidance that I provide at this point. Does that make sense?
Yes, thank you.
And if we have time, we will certainly deliver hard copies because the plans will be large. If we don't have time, I'm sure we can put them on a SharePoint site as at least a preliminary step.
What I would suggest is if you can provide them electronically by the night before the hearing, and then bring physical copies to the hearing, because it'd actually be harder for me to go from where I live in Tacoma to my office to pick up the physical files to then come back to Issaquah. So I would rather just any physical copies, bring them in, but anything I need to review can be provided electronically. Does that track
Sure.
with everyone?
We also have the ability to put it up on the screen if we
Right.
have it electronically, so
Okay.
that we can all look at something. If, I don't know what the printing ability is.
Yeah, okay. So then when we come back on the 20th, we'll obviously figure out the procedural, where we're at, all that. And then the idea was that the city had a few rebuttal witnesses, and then you might, in addition, is that the thinking, you might have your own rebuttal witnesses at that point. But hopefully we can get this wrapped up by the end of the day on the 20th, and I think that's it. Am I missing anything? Does that sound
I don't
like
think
we're
so.
all on the same page? Okay, everyone, while we're out, stay healthy, so that we can all, that need to be here, can be back here on the 20th. And I want to thank everyone for the professionalism and willingness to brave the dangerous world to be here today. So with that, we're going to go ahead and go off the record. Obviously, the record is staying open, but we are concluded for the day. Thank you, everybody.
Thank you.